All right, well, we will now go on to today's interview. And this is another, believe it or not, this is another HB6 story. It's just the story that just keeps on giving. It's been 5 years now that we've been reporting on HB6. And there's a new development, a hopeful development, and we'll hear all about that in our interview with Maureen Willis. So let's go ahead and play that.
I have been the Ohio Consumers Counsel since October of last year. I took over in, as I said, October. I've been an attorney with the Office of a Consumers Counsel for approximately 25 years. So I've been around quite a bit, done a lot of background work, but it's been very challenging as the agency head. So that's just a quick, brief background for you.
That leads pretty much into my first question. What exactly is the Ohio Consumers Counsel, and what do you folks do?
Thanks, Joe, for the question. We are a state agency that represents residential utility consumers. We advocate for residential utility consumers, and we educate residential utility consumers. We have a governing board that is bipartisan. It's appointed by the Attorney General, consists of farmers, residential advocates, and labor representatives. So that is our board. Our funding comes from a surcharge on your utility bill. For every $100 that consumers pay for their utility bills, 3 cents of that goes to fund our activities of our offices. And wanted to emphasize that we do provide education and outreach. We want consumers to be informed so they can make good choices about their energy services. We have a wonderful website, occ.ohio.gov. On the web sheet you'll find fact sheets, information on our advocacy, how to understand your utility bill, how to make choices about your energy supply, and also bill payment assistance, along with a lot of other areas. And we also are very active on social media. We are on X at OCC #4 consumers. We have YouTube videos, and we also put out consumer alerts. So we're very active in trying to get out and educate consumers about utility issues.
Okay, that's quite a bit that you folks are doing. The reason I asked you on today is because you recently did a filing in front of the Public Utilities Commission in opposition to a surcharge that OVEC is getting. And so before we get into the details, what exactly is OVEC that you're going up against in front of the Public Utilities Commission?
Well, for background, there are 3 of the 4 major utilities in Ohio, DP&L, AEP, and Duke, own shares of the Ohio Valley Electric Corporation, or OVEC. OVEC owns 2 1950-era coal plants, one in Indiana and one in Ohio. And so we are fighting the utilities who are asking for consumers to subsidize these old, inefficient, polluting coal plants. And if you go to our website, which we mentioned, occ.ohio.gov, you can see we have a ticker on our website that shows the cost to consumers of those coal subsidies that consumers have paid to date. And I'm looking at the ticker right now, and it's ticking and it's ticking. And we are, as of today, $249 million have been collected from consumers for the coal plant subsidies. The estimates are that that's going to increase, that subsidy will increase to at least $700 million by 2030 when it is supposed to end. So these are huge costs that are on consumers' bills. The subsidies started way back in 2020, and then we had legislation, which you may be familiar with, the HB6, that actually made the subsidies part of the law and requires the subsidies to be paid. And I might mention that although there have been a number of provisions in the HB6 bill that have been repealed, this is not one of them that's been repealed. So this is one we've been very active in advocating for a repeal It's just costing consumers way too much money, and it is a subsidy, and we would like to get that subsidy stopped.
Yeah, just about $250 million so far. So you've been opposing HB 6 from the beginning, from when it was first proposed way back in 2019. We often talk about how bad HB 6 is on this show in terms of its environmental impact, but it's actually hurt consumers in a number of ways, hasn't it?
I would agree with you, Joe. You're right. We have opposed House Bill 6 for a long time. It had not only these coal subsidies, but there were a lot of other bad things in that legislation. There were nuclear subsidies. There were revenue guarantees. It was really a financial bonus for the utilities paid for by the consumers. And as you say, the coal plants, not only do they present health issues for Ohioans, but they've been again, we've talked about the subsidy. We've been paying hundreds of millions of dollars for these coal plants. They're uneconomic, they're not profitable, and yet we pay for them day after day. In terms of going back to our opposition to House Bill 6, we testified against House Bill 6 7 times, and then after it was up for repeal, and after it was enacted, we also testified 11 times asking for the legislature to repeal that bill. They still have not repealed it, but we do continue the fight. We do get out and we do call for the reform and repeal of that coal subsidy, which is left from HB 6.
Early last year, one of the friends of the show, Molly Nichols, from the Sierra Club, she actually held a rally in the lobby of the Public Utility Commission office building, demanding that they conduct the audits that are required under House Bill 6. What those audits, if they show that the money is being collected, that just about $250 million so far is being spent imprudently, then basically the PUCO has a responsibility to end the subsidy. Could you tell us what's the difference between spending money prudently and imprudently?
Sure, I'll give you some examples. When we talk about prudent expenditures, and when we're talking about these coal plants, we mean that the coal plant should be operated economically, efficiently, and that the power that's produced and supplied in the market is bid into the market appropriately. And so it really goes to what is the cost of running these units, and how often should these units be run? If they're losing money, should we continue to run them, or should we only run them when they're profitable? So prudence can mean a lot of different things, but in this particular case, and I think we're talking about the 2020, what was spent in 2020 on these plants, if I recall, and that just for that 1 year, that piece was $100 million is what we were paying in subsidies for these plants. So the commission should be considering these, and in fact, that was our case, along with others at the Sierra Club and other consumer groups opposed the $100 million subsidy at the PUCO. And the PUCO must then consider the arguments, and it must make a finding that whatever actions the owners took with respect to these plants, that it was in the best interest of consumers. And there we argued there is no way that socking consumers with a $100 million bill and operating the plant as they did was in the best interest of consumers.
So that's why you're asserting that they are being run imprudently.
Yes, as we talked about, the plants are very old. The cost of producing powers out of these plants is very high, considering other available sources like gas and even renewable energy. So these plants are very expensive to run. And what the owners did is, instead of operating these plants at a time when they would be profitable, they essentially ran them 24/7. And so when you're running plants, when they're not profitable, you're going to incur losses, and they incurred a loss of $100 million. And that's what consumers had to pay to the owners of these plants. So the $100 million that consumers paid was because it was uneconomic. There were other power sources that were much cheaper, and that's all the money they could get in the market. So that $100 million is charged to consumers. And we said that, how can that be in the best interest of consumers? It's not. It was imprudent for these utilities to run these plants 24/7. They should have only run the plants when they would be assured of a profit. That is, when they sold the energy into the market, that it was sold at a profit and not at a loss.
So that's, I guess, what you'd call the difference between must run and economic basis.
Yeah, must run means that you keep those plants running 24/7, and economic means you only run those plants when it's profitable. And during this time period, during 2020, the utilities followed a must run scenario. They decided we'll run these 24/7. Doesn't matter whether we lose money or not, because guess who's paying the bill? We're not paying the bill. The consumers are paying the bill. So, part of the problem of it is that they have no skin in the game. There's no incentive for them to operate efficiently, because in the end, they know that the bill will come due to the consumers.
No risk.
No risk.
So one of the legal arguments that the utilities are making, that OVEC is making in here, when I read this, kind of made my jaw drop. They're arguing that because none of the members of OVEC have a majority share in OVEC, none of them can actually be held responsible for spending money imprudently. Is this as crazy as it sounds to be? I mean, and does it mean what I think it means, that if any group of corporations make a sub corporation that they all have minority interests in, none of them can be held responsible?
Joe, I think you hit the nail on the head. It's crazy. It's ridiculous. It's as if because you don't own a majority share, you shouldn't be responsible for the decisions of the organization. It's crazy, and it's also contrary to what the PUCO has held before. There were cases in the past where the PUCO was looking at, for instance, costs that were cost overruns in the nuclear facilities like Perry and I think Beaver Valley. Several cases out there where utilities tried that same argument. They said, "Oh, we can't be responsible for the overruns because we don't own a majority of the shares, and because we don't, you can't blame us." And the court, of course, well, luckily and fortunately, the PUCO did not buy that argument. So we're hoping they don't buy the argument this time, because I do think it would be very bad policy, and it would give an out to these companies when they shouldn't get an out. Their ownership, they own parts of this corporation. They get the profits from this corporation. They should also get the burden from this corporation. So exactly, I think it's crazy and ridiculous.
Here. And all those minorities, of course, do add up to 100%. So
that is correct.
So you folks filed this brief back on March 5th. Has there been reaction from the PUCO? What is the pathway here from this filing to OVEC actually losing the subsidies?
So Joe, we did file briefs. We filed two sets of brief, actually, initial and reply briefs. And now what happens is the PUCO will take a look at the briefs and will look at the evidence that's been produced and render a decision. Now there's no timeline on that decision, so we can't say it'll be out next week. Typically, it will take months for a commission order to be issued. So once they they issue an order, they make a decision. They decide, okay, either consumers have to pay the $100 million, or we're going to refund the $100 million or some part back to consumers. So it is up to the commission. Once they issue that order and make their determination, then we get the opportunity to ask them to reconsider. It's called an app for rehearing. And then after reconsideration, they will issue another order. And then based upon the order on reconsideration, we would look at the order and decide whether or not this merits taking an appeal to the Ohio Supreme Court. We are we often when we disagree with the PUCO's decision, we will take the issue up to the court and try to seek justice for consumers at the court. And actually, that's been, I'd say we're more successful at the court than we are at the PUCO.
You know, some of the most moving testimony against HB 6 way back in 2019, there was a pediatric doctor from Cincinnati who described how pollution from one of the plants was essentially killing children with asthma in the Cincinnati region. Keeping these coal plants open is continuing to hurt us in many different ways, isn't it?
We would say so. And again, I'm going to send you back to our website. On our website, we keep track of not only how much the subsidy you're paying, but we also keep track of the pollution that's caused by these plants. As of today, we have 49 million tons of CO2, 35,000 tons of NOx, and 28 tons of SO2. So those are all things that have been emitted from these coal plants, not good for people, not good, cause health hazards. And this is all in addition to the fact that not only are we ruining the Ohioans' health, but we're also charging them a lot of money to do so. So it's a double whammy from our perspective.
Okay, well, that's about it. Do you have anything you'd like to add?
Sure. Joe, I'd like to encourage the listeners to take some action and to have their voice heard. And how they can do this is contact your state reps and your senators and your representatives and ask them to work on the repeal of the HB 6 coal subsidies. Certainly you can make calls or letters. And there also is, in the case that we talked about in the 2020 case, you can file letters at the PUCO opposing the collection of the $100 million in coal subsidies. All you do is you can file a letter, and the PUCO has a website. The case docket is 21-477. And I'd also say a shout out for our website, occ.ohio.gov. We have more information there. You can see there the ticker on how much the subsidy is costing. You can see the health consequences, and you can look at our information sheets. So just in the end, it's important for consumers to be active, and one way you can be active is to let your voice be heard. Go over to the PUCO, and just as the group did earlier that we spoke about, and also talk to your senators, send them letters, give them calls, tell them that this subsidy is hurting customers financially and health-wise. So, and very important to stay active on these issues.
Okay, and that was Maureen Willis, your consumer counsel.